It's a fairly simple one. Well, it's not simple for me. We're going to court for a tribunal in a couple of months' time. We've been asked to put up a final statement. Is the statement to be concise about what the event was about, or can you include other information, or is it just basically what happened from the claimant's point of view?
What sort of tribunal, Ray?
It's a statement to do with a...
No, sorry, what sort of tribunal? Is it an employment tribunal or social security? An employment tribunal.
An employment tribunal, yeah.
And are you talking about a witness statement or a closing submission? They're two different things.
A closing submission. Basically what it is that she's been dismissed, she's going to court for unfair dismissal. They've said we want a final statement, which is what the court will obviously receive as her final statement. That is just about the event that caused the gross misconduct. Is that correct?
Okay, that sounds more like the witness statement than the closing submission.
It's the last witness statement. They just sort of say witness statement, and if you're
a witness statement, yes, yeah, they're two different things. A witness statement is the claimant, the individual who was dismissed, their account of what happened to them, so the tribunal can know what they say happened. A closing submission are the arguments at the end of the case. They're often done just by talking, but sometimes they're in writing. They're the arguments at the end of the case about why you should win and the other side should lose. But it sounds like you're talking about the witness statement. Yeah,
the statement of what happened and all the way through, and how she feels she was usurped if she does.
Fine. So it should essentially set out in as concise a manner as possible, but
and paragraphed, isn't it?
Numbered paragraphs, but giving all the detail that's necessary that she needs the judge to know.
So it's quite a long document.
And getting that balance right is impossible for trained lawyers, let alone people who aren't trained lawyers. That is the evidence that will stand as her evidence and what the judge knows about what she wants to say. The judge won't know anything that doesn't appear in that witness statement. The judge doesn't have a magical line into your friend's mind to know what she's thinking.
So every single thing that she believes happened to her, and at the end of it, why she feels she was usurped.
As long as it's relevant to the question that the tribunal has to decide, which is if it's a dismissal for misconduct case. The issues for the tribunal, there are going to be 5 main issues, and this should be set out in the case management document you will have received. But it's normally, did the employer honestly believe that the employee was guilty of misconduct? Did they have reasonable grounds for that belief? Had they conducted a reasonable investigation? Is dismissal a reasonable sanction? So, in other words, would the right result actually have been a written warning, not a dismissal? And finally, if they're arguing something called contributory fault, which means even if we made some mistakes in the procedure, she still did it, so she still would have been sacked and her compensation should be reduced, she's also got to explain why she wasn't actually guilty of what she's accused of.
Right. Okay. Absolutely. That's fantastic. Thank you for your help.